I think it's time. Can I start my presentation? Okay. Good afternoon, everybody. My name is An Kon-hyung. I'm teaching at Department of International Trade of Kyunggi University. And the topic which I will talk about today is the 2023 revised OECD guidelines for multinational enterprises. Actually, it was updated on 8th of June last year. So this is a very recent revision. And this is the sixth revision of the guidelines. The guidelines was enacted in 1976 for the first time. And this is a sixth revision. So this is a table which I will present today. Firstly, I'll introduce the background of the responsible business conduct and overview of the OECD guidelines for multinational enterprises. And then I will explain about NCP, National Contact Points, and dispute resolution mechanism of the OECD guidelines. And the fourth chapter, I will talk about the main contents of the 2023 OECD guidelines revision. And lastly, I will conclude my presentation today. Probably everybody knows about the concept of ESG. So to understand ESG's meaning, we need to understand what is responsible business conduct and business and human rights. So in 1960s, there were conflicts on natural resources such as oil and gas and nationalizations of newly independent nations such as Chile or Venezuela. So at the time, there was imbalanced power and predatory business conducts between multinational enterprises and host states. In 1970s, so the international community, they thought they need any controllable regime for multinational enterprises adverse impact. So regulating for multinational enterprises was fueled by International Telephone and Telegraph ITT case, which was the incidentally intervention on politics in Chile. So at the time in Chile, the president was Allende. And then Allende tried to nationalize the telephone company. So United States CIA and other multinational enterprises conspired to made a coup to change the president. So at the time, as you might well know, the Pinochet became the president by support of American government. So from this incident, UN and OECD or ILO or other international community and institution try to make regulations to control for those multinational enterprises, especially regarding the adverse impact. So in 1976, OECD Declaration and Decisions on International Investment and Multinational Enterprises established the Committee on International Investment and Multinational Enterprises, and it adapted OECD Declaration and Decisions on International Investment and Multinational Enterprises in 1976. So balance between liberalism on foreign direct investment and regulations on multinational enterprises' unilateral business activities. So this is a sort of like a manner of recommendation to member state. That means that has not any legally binding force. So before regulating multinational enterprises by UN's binding international treaties, OECD firstly voluntarily took anticipatory measures by the guidelines with non-binding power to recommend multinational enterprises keep corporate ethics in their field. So before the OECD guidelines was revised last year, the recent revision was 2011. And in 2011, most significant change was adoption of a separate chapter on human rights. And OECD guidelines adopted most of provisions and contents from the United Nations guiding principles for business and human rights. So OECD guidelines 2023 version is divided into two parts. First part is OECD guidelines for multinational enterprises recommendations for responsible business conduct. Hereinafter, I will call it RBC in a global context. So this is sort of like a substantive provisions. And second part is implementation procedures of OECD guidelines for multinational enterprises. So between the UNGP, UN Guiding Principles for Business and Human Rights, and OECD guidelines, most significant difference is OECD guideline has its own very unique dispute resolution mechanism that is conducted by national contact points. So there are 51 national contact points, NCP, all around the world. So 38 OECD member states has a duty, obligation to establish a national contact point. So part two is about the provision on dispute resolution mechanism. This is OECD guidelines composition of chapters. We have 11 chapters. The first chapter is concepts and principles, and second one is general policies, and third one is disclosure, and fourth chapter is human rights, and chapter 5, employment and industrial relations, and sixth chapter, environment. And the chapter 7, combating bribery and other forms of corruption. Actually, the title and many provisions and contents were changed in this chapter. So the title was also changed from combating bribery solicitation, and extortion. So before 2011 version, we focused only on bribery, but now the revised chapter 7 covered all other forms of corruption. And the chapter 8 is on consumer interests, so consumer protection. And 9th, science, technology and innovation. Previously, the title of chapter 10 was science and technology. And 10, competition, and last chapter is 11, is a taxation. So as I already mentioned, adhering countries should establish national contact points. And in Korea, the Ministry of Trade, Industry and Energy, MOTI, should be the coordinator. And multinational enterprises, OECD guideline should be complied voluntary due diligence according to the OECD guidelines. Then who can be the parties of the complaint, the disputes in NCP specific instances, the cases? Anyone who may be concerned with the guidelines. So multinational enterprises, workers or employees, and NGOs can submit a complaint against activities, especially adverse impact activities of multinational enterprises. And generally, a complaint is submitted to the NCP of the country in which the issues have arisen. But where the OECD guideline related issues arise in a non-adhering country in which an NCP has not been established, a complaint could be submitted to NCP of the respondent's home country. In other words, any breach of OECD guidelines happened in such as Philippines, they don't have a national contact point. But if the multinational enterprise's parent company is located in Korea, they can file the complaint with the Korean NCP, not Philippine NCP, because they don't have, okay? So this is a structure of Korean NCP. So chairperson is the Director General for Cross-Border Investment Policy of the MOTI of Korea. And commissioner is consists of 8 or less persons from the public and private sectors. And secretariat is conducted by the Korean Commercial Arbitration Board. And there is a mediation committee, and chairperson should be a NCP commissioner. And then NCP commissioner consists of 2 or 4 NCP commissioners or external experts. And this is a procedure of NCP specific instances dispute resolution case. So if the secretariat of the NCP receives a specific instance, the case, then they should proceed initial assessment, and they should decide whether they will go further investigation or not. So there are 6 criteria to decide whether to go or drop. And they can also offer good offices or mediation. Good offices is like facilitate both parties to talk, conversation. And through the mediation, they can reach on an agreement, or sometimes one party reject to participate in the process, or they cannot agree on the final solution. So firstly, if there is an agreement, then official announcement statement can be published. Or if they cannot agree on solution, or one party would not participate in the procedure, then recommend to the parties in the final statement. Okay, from now on, I will talk about the main contents of the 2023 revision, most remarkable changes in this version. So firstly, climate change and biodiversity. So there was no mention on climate change in the previous versions, in 2011 versions. And this revision newly adopted and strengthened the expectation of due diligence on climate change, biodiversity loss, or degradation of land, marine and freshwater ecosystem, deforestation, air, water, soil pollution, and mismanagement of waste. So before, there was no comment on climate change and biodiversity. So the lesson we can learn from this change, we need to prepare on many regulations or provisions regarding environment. And due diligence, there was an expansion of a scope for risk-based due diligence, and they included due diligence expectation for technology development, financing, sales, licensing, transactions and use, including data collection and use. Before, there was no mention on collection of data. And they also included new recommendations on how businesses should conduct due diligence on business relationships and the impacts regarding the use of products and services. And the revision also strengthened protection for at-risk individuals or groups who raise concerns regarding business activities. For example, there was a whistleblower in the multinational enterprises. If those multinational enterprises will attack or bully those whistleblowers, then they should stop. And they will do continuously those acts, then it can be, it's amount to breach of OECD guidelines. And fourth major substantive revision is adding updated recommendation for RBC disclosures, such specific examples of material information. So this revision tried to align with the 2023 revised G20 OECD principles of corporate governance, and adding specific example of material information. What is the material information? What does it mean by material? Such as composition of the board and remuneration of member and directors and key executives, etc. Those should be disclosed. And strengthening third-party review and assurance to enhance the reliability of corporate material information and disclosure reports. So the provisions and contents on disclosure was very strengthened. So those disclosure will be more and more important in the near future. And as I already mentioned, all forms of corruption was added. And they also mentioned on lobbying activities. So before they just mentioned refrain from lobbying, but this time they changed the word from refrain from to ensure, but still not should. That means there is no legal obligation, but more stronger stance was adopted. And from now on, I'll explain about the major procedural revisions of the OECD guidelines. So I already mentioned it many times, national contact points role is very important. So previously, they call only national contact points, but this time they changed the name. They added 4 RBC. So now NCP for RBC, and they added core criteria for functional equivalence for NCP activities. Those are VATA, visibility, accessibility, transparency, accountability. But this time, the revision added more criteria to make 51 NCPs get functional equivalence, equal function. So impartial and equitable and predictable and compatible with the OECD guidelines. I usually go to OECD headquarters once or 2 times a year in Paris to participate in the NCP meetings. And 51 NCP's role and function are quite different. So some NCPs in Northern Europe, they are very strong and they are doing very good role in their countries. But some African countries or other South American countries or other, the third countries, NCPs, the function and role is not equal to other developed countries' NCPs. So to enhance the functional equivalence among NCPs. The OECD headquarters and Working Party on RBC, they conduct peer reviews. So 3 or 5 and OECD secretariat staff and other NCPs representative visit to other countries' NCP and make a peer review. But it was a voluntary. But now, in this revision, peer review was mandated. So this is obligation. And there is an investment committee and working party on RBC and OECD secretariat. Their roles are different. So the revision, the 2023 revision specified the investment committee's possibility of determining issues related to the OECD guidelines in consultation with the assistance working party on RBC. And the chairperson of WPRBC is conducted by Professor Gabrielle Kaufmann-Kohler. She is a law faculty of Geneva University in Switzerland. And it specifies that the investment committee can decide on necessary recommendation for the NCP in question upon working party on RBC's suggestion. So the role of working party on RBC was getting very strong. So significant change was made. And regarding specific instance, it's a sort of like a mediation case. So there were many changes in this part. So specify the role coordinating between lead NCP and supporting NCP. So in some cases, the NGO or breached people file a complaint with normally only one NCP, but many cases, they file a complaint with a few NCPs at the same time. So Korean NCP, Netherlands NCP, and French NCP at the same time, they raise a problem. So we need to decide who should become the lead NCP and which NCPs should be supporting body. And clarification of the meaning of material. Well, before there was a new concept or explanation about materials meaning, but the revision provided that is satisfied if related to implementation of the OECD guidelines. That's enough. And also substantiated is satisfied if sufficient and reliable to support claim. When you go to the national court, if you want to allegate or claim, you should attach any evidence. This is the same, but substantiated means very different between national court system and NCP system. In NCP system, it's just satisfied if sufficient and reliable to support claim. And clarification of the type of conclusion of specific instances. Well, I will skip it. It's not important. Introduction of a provision on the basis of an NCP's decisions on issues at stake. I think this is the most important change in regarding procedural revisions, because NCP grievance mechanism, dispute resolution mechanism, does not have legally binding force like arbitration or litigation. So sometimes multinational enterprises reject to comply with the final statement of the OECD NCP result. So they changed if allowed by applicable law and the NCP's case handling procedures, the NCP may, not must, as at its own discretion, set out, provide its views in its final statement on whether the enterprise observed the guidelines. So the NCP members in the case, they can make their own view who's wrong. So this is very important change. There is no legally binding force, but there will be a much more strong pressure on multinational enterprises. And they also added a provision regarding follow-up measures that exist only in the explanation section of the implementation procedure to the body of the procedure. That means before there was no mention about the follow measures after the conclusion of the case, only in an explanation section commentary. But this time it added engage in follow-up where relevant once the specific instance has finished on the implementation of recommendations or, if any, the agreement reached by the parties. The NCP should publish a follow-up statement, and any follow-up that the NCP intends to undertake should also be referred to in the final statement, including deadlines to do so. So if the case will be closed before just everything's finished, recommendation is the only result. But now, after the conclusion of the case, 6 months later or 1 month later, NCP should convene all the parties again, whether they complied or conducted their agreement or promise. So it will be very good pressure beyond the naming and shaming. So this is my conclusion. As you might well know, the US technology hegemony competition with China and its value alliance strategy is getting harsh and aggressive. So the US tried to make a global supply chain reorganization. So kick away a ladder. They want to kick out the Chinese companies or Russian companies from the global value chain all over the world. So if the United States make their partners and allies more close, they need to give any reasonable reason to their partners to comply with their strategy. That is, I think, value alliance strategy. So value alliance, what is the value? Democracy and human rights, environment, and labor. Those are most difficult criteria that Chinese companies to comply with at the moment. So to reorganize the global supply chain, those criteria can be a very difficult hurdle or threshold for Chinese companies to catch up. So sustainable development and ESG is a hot issues all around the world, including Korea. So previously, OECD guidelines and UNGP, those are soft law. That means they don't have any legally binding force when those companies or entities will breach any rules or law. But recently, there are movement to from soft law to hard law, especially like what is it? Like Global Supply Chain Due Diligence Directive enacted by the EU. It's not it didn't come into force yet, but I think it will come into force very in the near future, very soon. And NCP mechanism, it was a sort of like a naming and shaming strategy they adopted. This is strategy because they don't have any tool to force those enterprises to comply with. But from the changes, revision from this version, I think NCP mechanisms, the effective and efficient role will be more enhanced and developed. So it will go beyond naming and shaming strategy. This is my presentation, and thank you very much for listening to my presentation. Thank you.
Thank you, Professor An. Professor An explained the main points of the OECD guidelines update after 12 years. I didn't know that NCP institution or NCP governance. Thank you for the good information. Do you have any question and comments, audience?
Yeah, Professor An, I also learned a lot from your presentation about the updated OECD guideline last year. Let me ask you a question about how the Korean corporation adapt themselves to the OECD guideline. Do they have any concrete or specific or the material activities to integrate the OECD guideline in their ESG strategy or the business strategy or that?
Well, actually, I also used to work at the OECD guidelines secretariat. Secretariat is conducted by Korean Commercial Arbitration Board. I was the director and team boss. But still now, the recognition on OECD guidelines in Korea is very low. So, and this OECD guidelines was revised last year, 8th of June. So probably most of companies would not recognize this revision or existence of OECD guidelines. So we need to promote more aggressively. But fortunately, many multinational companies in Korea, they recognize the importance of ESG. So this is one of the part of ESG. So I think if we would like to promote more aggressively, I need to explain the real case studies regarding NCP mechanisms. So I already suggested to the ministry and the Korean Commercial Arbitration, the Secretariat, that this year we need to make more seminar or events to explain the case and the lessons. That is very important. And I think during April, 4 important members of EU and OECD RBC Center will visit it, are scheduled to visit to Korea. So I think I will organize one international seminar, and I will invite, of course, Professor Chong and other scholars and experts in person, but not so well recognized.
Thank you.
Okay. Thank you, Professor An. Yeah. We are over our morning session. Yes, thank you, everybody. We needed to have a 1 hour break for lunch and come back at 1 p.m. in Korea time. Enjoy your lunch.
Thank you.
Thank you, Professor.